Welcome to this episode of Risk on Air. As a solicitor, can you save a client from a bad bargain? What are your obligations to do so if you smell a rat? In this podcast, Janice Purvis, solicitor and manager of practice support services at Law Cover, and Veronica Chapman, partner at Kennedy's, specialising in the area of professional indemnity disputes, discuss a solicitor's duty of care to avoid economic loss to a client and how this relates to managing risk in everyday legal practice. In short, to what extent are solicitors expected to act as a financial soothsayer for their clients?
Thank you for joining us today, Veronica. It's
Hi,
very
Janice.
much appreciated.
It's a pleasure.
The topic of the day, mortgages. From time immemorial, solicitors have been advising on mortgage transactions, but historically there's been a grey area when it comes to a solicitor's duty to advise on the commercial wisdom of these transactions. Veronica and I will examine the unsettled legal principle of prenumbral duties, there's my tongue again, and how three key cases have changed the risk in these areas and what you can do to manage that risk, which is probably the important point. O'Brien and Hooker Holmes. Do you want to tell us about that, Veronica?
Well, the facts are pretty dry, so I perhaps I won't even bore you with all of that, but I can give you a little bit of historical background, and I can say that O'Brien is one of those cases which most solicitors, I think, practicing in property and mortgages remember very clearly. It was a landmark case. It was a watershed, all of those platitudes and cliches, Janice.
Yes.
But only to the extent that I think solicitors or legal practitioners around the state heaved a massive sigh of relief when that decision was delivered. Because for the first time, I think we all felt in about, when was it, 1996, 95? Or whenever the case was handed down.
Yeah.
I think we all felt that we actually had a clear statement confining the duty of solicitors to what one would normally expect.
And this is a typical case. The couple had limited resources, education, experience, and only basic financial planning. And any solicitor would have seen that the couple did not have sufficient means to repay the mortgage and have any money left to live on. The solicitor failed to explain the financial implications of entering into the particular transaction. And the court ruled at first instance that the solicitor had therefore failed to meet the requisite standard of care. The solicitor argued that there was no further duty beyond the retainer. In other words, to explain what the mortgage documents were and the effect of the mortgage documents. Solicitors, I think you'll agree, Veronica,
Yes.
Are not financial advisors, and more particularly under the professional indemnity insurance policies, they're not insured to provide financial advice.
Exactly. And I think the significance of O'Brien at the time was that up until that point, there had been a fair few decisions which, in fact, did find solicitors liable for what I could call add-on responsibilities. And O'Brien was a definitive decision. It's a very, very clear statement by the Court of Appeal as to confining your duty to the terms of your retainer and purely and simply that. So if your retainer is to advise on mortgage documents and what they mean, then that is what you do. And anything above and beyond that, one doesn't go.
I love your description of add-on duties. It's much, much easier to say, as it has become known in legal field, as the prenumbral duty.
Yeah. Well, I got to be honest, Janice, I can't pronounce that, so I say add-on. Okay, that's the only way to do it. But I also want to say about O'Brien, and this is where it becomes interesting, and maybe I'm being clever with the benefit of hindsight or 20/20 vision, but there is an out in that decision. There's an out which the subsequent cases, which I think we're going to be talking about, pretty much rely on. And at the time when O'Brien was handed down, I don't think too many people paid attention to that out, if I can call it that. And I'm talking about there's a particular part of the judgment And not obviously the specific words, but what the Court of Appeal says very clearly is the solicitor's duty is found in the terms of the retainer, pause, and the ambit of any additional assumed responsibility. Okay? And to my mind, following the history of the cases from that point on, it's that and additional assumed responsibility that subsequently assumes a lot of importance when you look at the history of the cases. And of course, from Law Cover's perspective, you've been a major player in every single one of those cases, unfortunately.
Absolutely.
Yeah.
And as Veronica pointed out, while at first instance a duty was found, the Court of Appeal said very, very clearly that it wasn't. But the perfect segue into our next case, and this is very near and dear to my heart because it was actually a file that I handled here at Law Cover for many a year. It's RIS and Perpetual Trustee, and it's a 2007 case. What this case indicates that Citicorp isn't an isolated case, and a similar situation arose in RIS where non-English speaking immigrants refinanced their home. However, the difference here is that they were refinancing their home to invest in what turned out to be a fraudulent Ponzi scheme. They obviously didn't know it in the past. This time the couple was experienced in business, notwithstanding their limited English, and they knew that the proposed scheme that they were investing in was very risky. It was a case of if it looks too good to be true, it is too good to be true, with interest rates being touted at about 48%, and they had personally seen money invested and being paid back to clients. So they knew it was risky, but still they were greedy, I suppose. I didn't say that, did I? The solicitors were retained to act on the loan and mortgage transaction only, not on the financial transaction. However, they did become aware that the clients were borrowing these additional funds for the risky investment and limited their retainer to advise on the mortgage transaction only, specifically in the file notes. The solicitors told their clients to seek independent legal and financial advice for the other transaction. They weren't in a position to do so. The transaction ultimately failed, and at first instance, do you want to take it from here, Veronica?
Wow, yeah. Well, the court at first instance was extremely critical of the solicitor's conduct, I think it's fair to say. And Janice, you were there for most of it, and
absolutely, and I think very unfairly, yes,
very unfairly. And I think fundamentally, the way I read the first instance decision was, again, going back to the point I made about the add-on. I think that is in effect what Justice Brereton, who delivered that first instance decision, was saying. What he was saying was that in the circumstances of the case where it ought to have been apparent to the solicitors that not only was there real risk, but there was a threat to the financial well-being of the clients.
Absolutely.
And that in those circumstances, the solicitor wasn't discharging her duty by simply saying, you must go off and seek independent legal and financial advice. You've got to go a little bit further.
We're not quite sure what that little bit further
because
is.
he never said so.
Do you have to put them in a taxi and...
Well, exactly, exactly. But it was enough, I think, for the first instance decision or the first instance judge to be able to say there was more than that. You had to explain a little bit more about the implications of it. But again, no detail was given in that first instance decision as to what implications should have been alluded to and what physically could have been done. And of course, that, to my mind, was one of the main reasons why, the way I read the decision, the Court of Appeal was, in its own polite way, pretty darn critical of the first instance decision.
Well, the first instance decision, and I quote from the judgment, a solicitor, and pardon the double negatives here, they're not mine, they are Justice Brereton's, A solicitor who is carrying out a transaction for a client is not justified in expressing no opinion when it is plain that the client is rushing into an unwise, not to say disastrous adventure. I guess one thing that I took out of this particular comment was that if you had provided the clients with this advice and it had turned out to be a wonderful adventure and they had missed out on making a fortune,
they'd sue you.
They would sue you.
Absolutely.
For negligent advice. So it
and
was...
in fact, that's what one of the decisions in the Court of Appeal specifically pointed out, that you can't just express an opinion per se. Express an opinion about what? Express an opinion and say, oh, look, I'd do that if I were you. That's not the way that the duty works.
So once again, like O'Brien, the Court of Appeal came to our rescue and reversed the decision.
They did, but, and again, can I just highlight one very interesting point, though,
Absolutely.
in reversing the decision? The president, I think it's the president of the Court of Appeal in Riz, specifically quotes himself in an earlier case of David and David, which I think a lot of us would be familiar with as well.
Especially at law cover.
Especially at law cover. And in that earlier decision, which they rely on in Riz as well, they specifically question the existence of this add-on or prenumbral duty. They specifically question it.
Yes.
They say words to the effect of, the existence of such a duty is to be strongly doubted. Okay?
Yes.
So I'm just trying to sort of put it into context as to where we go in a couple of years' time. But again, the court then goes on to say, and here's the crucial part, and with apologies, I'll quote this directly.
Absolutely.
Okay. If, however, the solicitor, during the execution of the retainer, learns of facts which put them on notice that the client's interests are endangered, unless further steps beyond the limits of the retainer are carried out, the solicitor may be obliged to speak. That's a heck of a caveat, isn't it?
Absolutely. But it does provide a perfect segue
into what they ultimately did.
What they ultimately did.
Absolutely.
I would like, just before we leave the Riz matter, I'd like to say that this particular solicitor in this matter, she was an employed solicitor. I think probably just over 5 years' experience. Her execution of the retainer was immaculate. She gave excellent explanations. She wrote incredibly detailed file notes, especially in respect of advising them to get financial advice and the riskiness of the scheme. So I think the comments made by Brereton at first instance were most uncalled for.
Indeed.
And this was a solicitor who I really, to this day, cannot see what else she would have done. And the Court of Appeal backed us up that way.
Yes.
But as I said, on and we go to Provident Capital versus Papa. I mean, that's a short name. On all the podcasts, all the citations will be on the website and you'll be easily able to access the judgments straight from there. So after the two key cases, and they were key cases, with the clear message along Papa. Yeah. Now, the facts in Papa are not dissimilar to Riz. The client, Mrs. Papa, wanted to mortgage her home to give her some money to fund his gym business, which was struggling at the time. Provident, who was the lender, required Mrs. Papa to get independent legal advice, as occurs in all mortgage transactions. The solicitor gave advice saying that if the son failed to pay back the money, she was going to lose her house. I mean, that's what a mortgage is.
Exactly.
She understood what a mortgage was. The son's business failed and Provident commenced proceedings for possession of Mrs. Papa's house. Mrs. Papa was not happy, of course, as you can imagine.
Yes.
Essentially, Mrs. Papa said that the contract with Provident was unconscionable. She was a pensioner. How was she ever going to pay back the mortgage? Provident then brought a cross-claim against the solicitor and alleging that he had provided negligent advice with respect to the mortgage, and it was really the solicitor's problem. What was the first instance judgment, Veronica?
Well, the first instance judgment, again, to my mind, exactly followed what I think the Court of Appeal was trying to indicate in Riz. So I thought, with the greatest of respect, the first instance trial judge did an exemplary job.
We all think that the first instance trial judge did an exemplary job, which may give you a hint as to where the Court of Appeal went.
Yeah,
But
well, the first instance judge, I think, specifically and strictly applied the principle in Riz. You can find the retainer, you look at what you were obliged to do, and you look at the explanations that were given, and in those circumstances, the trial judge found that there was no relevant breach of duty or retainer. Then, of course, we move on to the Court of Appeal. The president of the Court of Appeal sat in both Riz and in Papa. So you've sort of got a bit of a continuity.
Absolutely.
Okay. And what the Court of Appeal did, and it's a very, very long judgment with a lot of examination of relevant authorities. But what I think it comes down to is this. They accept that solicitors are not ordinarily, stress the word ordinarily, retained to advise on the wisdom of transactions. So that is your O'Brien point. Absolutely. It's also your Riz point. But they then say, however, that the retainer, even though you may not be obliged to advise on the wisdom of the transactions, you actually do have an obligation to give advice on what they refer to as the practical implications. Now, if I can just pause there, and at the risk of being facetious, I've grappled a bit with the distinction between the practical implications and the wisdom of particular transactions, and I'm not entirely sure that there's a distinction sufficient for you and I, for instance, to be able to explain it to our fellow practitioners so that we all know exactly where we're going in terms of a roadmap. But all I can do...
Are you saying we need yet another case?
No, I'm certainly not saying that, although from a professional viewpoint it'd be nice to actually get somebody who goes back to O'Brien, get a case that goes back to O'Brien. But what Papa says is that you have to advise on the practical implications. So I hear you say, what does that mean in the present circumstances? But what it meant in this case was that, according to the majority, what the solicitor had to do was to explain to the lender, to the mortgagor, that if her son defaulted and if his business went bad, she would be at risk of losing everything. What he should also have done was give a very strong recommendation to the client that she should go off and get independent financial advice. And in making that recommendation or giving her that advice, he should have indicated to her the danger to her of her son's business collapsing. That's what the Court of Appeal says was intended by the expression practical implications.
And that is the fact that all the security was with her, and she was totally and utterly dependent on the success or otherwise
of this business,
of the son's business.
So it was not enough. It was not enough for the solicitor to say to his client, if the loan is not paid, you will lose your property.
Yes.
You should go one step further and you must say to the client, or strongly advise the client, the success of your son's business is going to affect greatly your financial position. Therefore, you must go off and get independent financial advice.
And essentially, the repayment was totally out of her control.
Exactly.
The son would be making the repayments.
Exactly.
She was a pensioner.
Yeah.
She was putting up for security her home, and actually she had a small business that she ran out of there as well, which she supplemented her pension with. Had financial advice been recommended, it's interesting in this particular circumstance that Mrs. Pappa had previously lent her son money before.
Exactly.
And it had been repaid.
Yep.
We raised the causation defence
Yes.
that Mrs. Pappa was going to lend the money to her son no matter what the solicitor said to her, as this is what mothers do with sons, I guess. Having got to have a son, I suppose, that's what mothers do.
Well, yeah. Sorry, go on.
No, that's all right. So McFarlane actually said a solicitor's obligation is not simply to explain the legal effect of documents, but to advise his or her client on the practical implications of the client's entry into the transaction of the subject of the advice.
Yeah.
And again, as you said, I think very, very clearly what he should have said. He's gone that step further. It really wasn't an add-on per se, as they talked about.
Yeah, look,
You disagree?
No, I don't disagree, but it's, as I think you said in the introduction, it's very much a grey area. Now, I realise that's not helpful for the profession or for practitioners.
Not when it comes to black and white law.
Not when it comes to black and white law, and trying to get yourself into some sort of framework where you can be confident that you are doing the right thing by yourself and by your clients, really. I probably do think that what the Court of Appeals said is an add-on in a way. But I also, at the same time, think that the decisions in Riz and in O'Brien did leave it open for the decision in Pappa to be made. I think there is an out there, whichever way you look at it. But one of the things I find interesting about Pappa, and in a couple of subsequent cases which have not been reported, or some in which I think a number of us have been involved in, which have not gone the distance, if I can put it that way. But the interesting thing about Pappa is that it highlights what I think is a fairly common factor in these sorts of cases. And to me, the crucial factor in Pappa was that the loan was being obtained for the benefit of a family member, and therefore the court, I think, had perhaps an unexpressed concern that there was a conflict on the part of the client in terms of the client's best financial interests and her family interests.
Absolutely.
And I think, without obviously the court having specifically said this, that is a real factor, and that's a thread which does run through a number of these decisions. Would you agree with that?
Absolutely. And I mean, you can't just look at the transaction and just look at the documents and advise on the documents. You've actually got to ask questions. You've got to ask why, how, when and why this money is being borrowed. And in particular, in these days where it is so difficult to purchase a house and there are many parents who, again, are borrowing funds with security of their own premises and reliant on their children making the payments. And also at other times going guarantor for the loans. So you really need to ask more questions as opposed to just looking at a mortgage document and saying, here are the effects, 1, 2, 3.
Absolutely agree with that. And I think that there's been a lot of, and Janice, you'd be more aware of this than I think most people, there's been a lot of wringing of hands in relation to Pappa. It's a case that I think has concerned the profession greatly in terms of opening up the goalpost again, if I can put it that way.
Absolutely.
But I'm not necessarily saying that Pappa has been a great decision for the profession, but what I am saying is that it's an explicable decision. When you look at the background, when you look at the position in which Mrs. Pappa was in. Yes, she had loaned money before, but yet again, it was to a family member. So there automatically was a conflicted interest on her part. And I think that's what motivates the decision.
So the first alarm bell certainly rings with if the client is not getting the benefit of the money, be it the family member the friend
Exactly.
or whoever happens to
Exactly.
be. And, you know, you've got to, as I said, be proactive and know the circumstances of what is happening. And also, if you come into the solicitor comes to know the information that is relevant to the client's decision to proceed with this transaction, again, the solicitor has to disclose this. In the Papa case, it was came out that the solicitor had heard, I think, rumours that the son's business might have been in difficulty.
That's right.
He had acted for the son in the past, was not acting for the son at the moment, but apparently he had heard these rumours.
That's right.
So again, that was a huge alarm bell that should have been ringing all around town.
In other words, the solicitor not only should have known, but probably did know enough to have a suspicion as to the health of the son's business. And that, I think, was a very relevant factor.
Okay.
Yeah. And sorry, just again, expanding on that point, I think that is also a crucial point for all of us when we are advising clients in this sort of circumstance. The more that we know or suspect about something, sure, it may not be in our strictly defined written terms of retainer or our costs agreement or anything else. It may not be there. But the more we actually know about the background, the more our duty, if I can call it that, increases.
It might not be in any of those documents, but I'm hoping that it will certainly be in the file notes.
Exactly. Yeah.
So what are the take-home messages? And I mean, that's what we're here today for, is what are the take-home messages? Consider the bigger picture beyond the legal advice, the direct and indirect impacts, along with that magical phrase, the practical implications. You've got to consider the vulnerability or experience of the client. Again, recently there has been a report into elder abuse. We have an ageing population. As I said before, we also have a situation where parents are lending children their money. You have to look at this context that are they a vulnerable client?
Yes, and again, your point earlier, the vulnerability, I suppose, to express that in practical terms, one of the indicia of vulnerability is going to be, is this client getting the benefit of what he or she is putting herself in hock for? You know, because that's what it boils down to, I would think.
Absolutely.
Yeah.
And in particular, I mean, I think rural practitioners will find this happens a lot. The family tends to come in and the family wants to sit in on the discussions, and I think you've got to very clearly explain that this can't happen and that you've got to see your client. Again, it comes down to identifying your client. Who is your client? And you must see them alone. Where there may be multiple clients, again, it may be necessary to meet them totally separately away from each other, depending on the situation. You've got to be aware of the conflicting and differing interests, particularly when, as we say, the transactions involve family members. English as a second language. This is coming up more and more. Please do not rely on a family member to interpret for you. We've had one matter at Law Cover where the daughter said to the solicitor, "Mum doesn't understand English very well, but don't worry, I'm here, I'll translate for you." And he, thinking that this was appropriate, she spoke in Greek to Mum. The solicitor did not speak Greek. He had no idea what she was saying to Mum. You have to use an independent interpreter, which is not a big deal these days.
No, it's not.
You can get them on the phone. Make sure you get one that's NATI accredited. But again, that's an issue that often comes up in these mortgage cases. And of course, the big message, make it abundantly clear that you're not providing them with financial advice, that they should get some independent financial advice. If they don't do it, it's a matter for them. And as I said, keep a record of all the advice that you give them. these are practical steps that you can take to manage the risk associated with these types of transactions. You need to be aware of the type of client and the type of transaction. And as any solicitor knows, if we're dealing with a businessman who has done many commercial transactions, your advice again is going to be different.
Yeah.
So what's the final catch line for the Papa case? So we are left with the practical implications, or as I love Veronica's phrase, the add-ons, and of course the word that none of us can say, the prenumbral duty, is always going to be there.
Yes, it is.
It is always going to be there until, of course, there is another case.
Until there is another case, and I very frankly doubt that's going to happen in the foreseeable future, Janice.
Well, thank you very much for joining us here today,
Thank you.
Veronica.
Thank you, Janice.
Thanks for listening to Risk on Air by Law Cover. Join us for the next episode and subscribe to stay up to date. For cases and references mentioned in each podcast, visit lawcover.com.au.